We will go on the record in the matters 25 CF 64, 25 TR 291, 292, and 293, 26 CF 51. State of Wisconsin versus Sean Schaaf. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Schaaf, who is appearing in person with his counsel, Daniel Chapman. We're set here today in these matters for status conferences as well as a preliminary hearing. This matter is proceeding as a preliminary hearing in 26 CF 51. Mr. Vila, please call your first witness.
Thank you, Your Honor. The state calls Officer Tyler Hoagland.
Officer Tyler Hoagland. I think this is the first time I've seen you up here testifying. Please come forward, raise your right hand. You're going to be sworn in, and then come have a seat over here on the witness stand.
You swear that the testimony you're about to provide today for this matter is the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may begin.
Can you please state and spell your name for the record?
Tyler Hoagland, Tyler, last name Hoagland, Hoaglund.
And how are you currently employed?
I'm employed with the St. Croix Tribal Police Department.
And how long have you still been employed?
6 months.
And prior to today's hearing, did you review a criminal complaint in Burnett County case 26 CF 51 as it relates to Sean Schaaf?
I did.
On April 16, 2026, did you conduct a traffic stop at the intersection of Lake 26 Road and Minerva Road?
Yes.
Is that area located in Burnett County?
Yes.
Why did you conduct the traffic stop?
I conducted the traffic stop for no illuminated split lights.
Did you make contact with the driver?
I did.
Who was the driver?
Sean Schaaf.
How'd you identify him?
His Wisconsin driver's license.
Okay. Do you see that same Sean Schaaf sitting here in the courtroom today?
Yes.
Could you please identify Mr. Schaaf by where he's sitting and what he's wearing?
Yes, he's sitting in the right chair there in a looks like to be a t-shirt, a gray t-shirt, black t-shirt.
The record reflects that Officer Hoagland has identified Mr. Schaaf.
Was anyone else in the car?
Yes, there was what appeared to be 3 children under the age of 16.
Okay. Did you speak with Mr. Schaaf?
I did speak with Mr. Schaaf.
What did you talk about?
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. At first glance, this may sound like a routine traffic stop over a simple license plate light, but courtroom cases often take dramatic turns when officers begin noticing signs of impairment. With 3 young children reportedly inside the vehicle, the stakes suddenly become much higher. Watch closely as the officer explains exactly what transformed a minor equipment violation into a felony-level criminal proceeding. The details presented from this point forward will determine whether the court believes there is enough evidence to move this case toward trial.
I was just conducting a simple traffic stop. I collected his the proper identification, his insurance, and then I kind of went about my day is to running him through our tribal dispatch system, and at that point, I mean, I approached his vehicle again and observed his eyes seemed to be glossy, and the vehicle smelled like it was emanating an intoxicant from the vehicle, which is why I conducted my OWI investigation.
When you say conducted an OWI investigation, what did you do?
I asked Mr. Schaaf to step out of the vehicle and to stand in front of my patrol vehicle. And at that time, he complied. He got out. I asked him how many beverages he had. I can't remember the exact amount he said. He said that he had some bush light, and I just simply told him that I would be conducting just some standard field sobriety tests to make sure he's okay to drive his vehicle to his destination that he was traveling. At that time, I conducted the standard horizontal gaze nystagmus, the walk and turn, and the one leg stand.
Did you notice any clues on the horizontal gaze nystagmus?
Yes, I did.
How many clues did you observe?
I don't quite recall.
Okay. The next test you conducted was the walk and turn, correct?
Walk and turn, yep.
Did you notice anything there?
Yes, I did.
What'd you notice?
I noticed that when he was walking, he was unable to keep his feet when he was walking. He was unable to keep his feet heel to toe like I instructed.
Mhm.
And I don't recall. I believe he took the wrong amount of steps, but I can't completely remember on that.
Okay. And the other test you conducted, what was it?
It was the one leg stand.
Did you notice anything there?
Yes, Mr. Schaaf was unable to keep his balance through the duration of the test, and he was swaying.
Okay. What'd you do after completing the field test?
After completing the field test, I asked Mr. Schaaf if he was willing to submit to a preliminary breath test, and he declined wanting to do that. And at that time, I placed him under arrest for suspicion of operating under the influence.
Now, did he submit to chemical testing of his blood?
Yes, he did.
What were the results there?
I don't recall. I just got the blood tests back, and I just issued the citation not too long ago. I don't recall what the reading was, but I do know it was above the legal limit.
Okay. So you said you placed him under arrest for operating while intoxicated.
Yes, sir.
Does he have any prior convictions for operating while intoxicated?
Yes, he does. To my knowledge, I believe he has 4 of them.
Okay. And at the time of this incident, was Mr. Schaaf on bond?
No, he wasn't. He did explain to me that he had court for a similar offense the following Monday.
This is one of the most important moments of any preliminary hearing. Notice that the prosecution isn't trying to prove guilt beyond a reasonable doubt today. They only need to establish probable cause that a crime was likely committed and that the defendant likely committed it. The officer's testimony about glossy eyes, the odor of alcohol, field sobriety performance, refusal of the preliminary breath test, and the later blood test all combine to build that foundation. But what do you think? Is this evidence convincing enough to justify moving the case forward? Or would you need stronger proof before sending someone to trial? Let us know your thoughts in the comments.
No further questions, Your Honor.
All right, Mr. Chapman?
Were you wearing a body camera that night?
I was.
Was it active the entire time you were communicating with Mr. Schaaf?
Yes.
And does your squad car have a camera on the dash?
It does not, no.
Okay. Did you ever investigate the tail or the license plate lamp?
I did look at the license plate lamp, and as well as the other officer that was on scene.
And what did you see?
It was not illuminated.
Okay. And you said Mr. Schaaf declined to blow into the preliminary breath test?
Yes, sir.
No further questions.
Any redirect?
No, Your Honor.
All right, you're excused. Thank you.
Thank you.
And I will be moving to admit a copy of his driving record and evidence.
All right.
Thank you.
Any further witnesses?
No, Your Honor.
Any witnesses, Mr. Chapman?
Just want to double check this. No, Your Honor, no witnesses for today.
Any argument, Mr. Chapman?
No, Your Honor.
All right. Based upon the testimony of Officer Hoagland, the court does find that there's probable cause to believe a felony was probably committed in Burnett County, and it was probably committed by Mr. Shaw. Therefore, the court will find the probable cause and bind the matter over. Information, Mr. Vila?
Thank you, Your Honor. I am in the process of filing the information. It will mirror the criminal complaint.
Proceed with arraignment or set it for another date, Mr. Chapman. He's having surgery, is he not?
Do you know when that is?
The 29th, I have it scheduled for
The
July.
29th, you have what?
Surgery scheduled.
Okay.
Do you remember what the arraignment was? That's just where we plead not guilty.
Yep.
So we can do that today. He's
Yep.
saying the charge is going to be the same as what's in the criminal
Okay.
complaint.
Yep.
And you just have to know if you wanted to change judges. But if you didn't do that last time, there's no reason you
Yep.
want to this time. We can do the arraignment today, Your Honor.
He understands the charge and the maximum penalty, or charges and the maximum penalty.
He does, Your Honor.
Waive formal reading.
We will waive reading of the complaint and plead not guilty to the 2 counts.
Not guilty plea will be entered on his behalf. He is entitled to a jury trial. You would be entitled to a speedy trial should you request one. We need to get the matter scheduled for a status. You're having surgery on July 29th. And did your doctor give you an approximate amount of recovery time?
Not really, but he said I'll have to have a catheter for 2 months.
And this is a Mr. Schmitz.
It is, Your Honor.
September 10th in the morning, Mr. Chapman, or
One moment.
afternoon, whatever is easiest for you that day, if it works. Oh, you are coming here on that date anyway. at
Yes, I am.
9 o'clock. 9 o'clock on September 10th. Okay, hopefully, I mean, that gives you, wait, oh, I was going by today, July 29th. Off the record, I have had people here with catheters before, but he can appear by video conference or telephone or something like that if you wish to do so.
Yes, Judge.
Okay, back on the record, both may appear by video conferencing or telephone if it works better if you don't have good internet capability. Okay, Mr. Schaaf. So we'll get an update and a status on September 10th, where you are in recovery after your surgery, those kinds of things. You can come get your notice and you're free to go.
Thank you.
Thank you.
Today's hearing demonstrates exactly how the preliminary hearing process works within the criminal justice system. The judge did not decide whether Sean Shaw was guilty or innocent. Instead, the court determined that the prosecution presented sufficient probable cause to bind the felony case over for further proceedings. A not guilty plea was entered, future court dates were scheduled, and the defendant will now have the opportunity to challenge the evidence as the case continues. This hearing reminds us that every stage of a criminal case serves a different legal purpose, and today's ruling was only one step in a much larger process. If you found this courtroom breakdown informative and as fascinating as we did, be sure to hit the like button, share your opinion in the comments, and subscribe for more in-depth courtroom analysis and real legal case breakdowns.